I will now introduce Lord Phillips as our commencement speaker. I'd like to also invite you to extend a word of welcome to Lady Crystal Phillips, his wife, who also traveled from England to be here today. We have been fortunate to have teaching with us at Washington and Lee last year and in the year that is to come, and we hope for the indefinite future, a member of the Supreme Court of Virginia, Justice Donald Lemons, who is here sitting with our faculty today. And I want to thank Justice Lemons and his wife, Carol Lemons, who are here with us today, for helping us to secure the invitation to Lord Phillips and to be the hosts for Lord and Lady Phillips during their weekend with us. Thank you, Justice Lemons, and thank you, Carol. In the year 1946, President Harry Truman introduced Sir Winston Churchill to deliver an address at Westminster. Not Westminster in London, but tiny Westminster College in Fulton, Missouri. Winston Churchill traveled to Missouri and delivered a speech that would become one of the great speeches of his life. It is known as the Sinews of Peace Address. And I will share with you a few words from Winston Churchill to introduce our speaker. We must never cease to proclaim in fearless tones the great principles of freedom and the rights of man, which are the joint inheritance of the English-speaking world, and which through Magna Carta, the Bill of Rights, habeas corpus, trial by jury, and the English common law find their most famous expression in the American Declaration of Independence. All this means that the people of any country have the right and should have the power, by constitutional action, by free, unfettered elections, with secret ballot, to choose or change the character or form of government under which they dwell. The freedom of speech and thought should reign, that courts of justice, independent of the executive, unbiased by any party, should administer laws which have received the broad assent of large majorities or are consecrated by time and custom. Here are the title deeds of freedom which should lie in every cottage home. Here is the message of the British and American peoples to mankind. Let us preach what we practice. Let us practice what we preach. There are few lawyers or jurists in the world who stand as greater exemplars of that spirit of Winston Churchill than Lord Nicholas Phillips. Please join me in welcoming him as this year's commencement speaker.
Ladies and gentlemen, members of the class of 2009, it is a great pleasure and honor to be the only one here who has not earned his degree. And so the first thing I want to do is to congratulate all of you who have earned your degrees. I can remember when I was in your position, and the feeling of joy and relief at having made it, coupled with apprehension at the thought of going out into the real world and trying to earn a living with the knowledge that I had acquired. And I'd also like at the outset to congratulate your families and friends. It makes it much easier to get a degree if you have the support of those you love. Moral support, and I dare say sometimes a bit of financial assistance as well. I've been reading your Dean's account of the year that you've completed. Professional development through simulated and actual practice experience. Well, I've had just about 50 years of practice experience, so perhaps I've earned my degree after all. I wonder why you have decided to become lawyers. I suspect that your motives vary widely. Some of you may be motivated by a desire to uphold the rule of law, to help those in society who are deprived to obtain their legal rights, to play your part in meeting the challenges that are facing society today. Others may be motivated by the lifestyle that the successful lawyer can enjoy. Others may think that practicing law is going to be fun. Others of you may not be quite sure what you want to do and may have decided to give law a try and see how you make out. I think I probably fell into the last two categories. Certainly, I regret to say I was not motivated by a burning desire to help society when I was called to the English bar. Indeed, I had no idea what area of the law I wished to practice. Chance played a role. I'd done national service in the Royal Navy, and I met a barrister who told me he specialized in admiralty work and invited me to join his chambers. Up to that moment, I hadn't even been aware that admiralty chambers existed. But I started off specializing in shipping law before expanding my practice into other areas of commercial law. I accepted an invitation to go on the bench about 20 years ago, but never regretted making the change. In recent times, as you've heard, I've had the good fortune to hold a series of most interesting judicial offices. And I've come increasingly to realize the vital importance of the rule of law and of the role that lawyers play in upholding it. My wife, Christine, as you might have guessed, is French. So she comes from a country where the legal system is inquisitorial rather than adversarial. Initially, she found it surprising that I numbered among my friends some who did nothing but criminal defense work, and who would sometimes be rejoicing at having persuaded a jury to acquit a particularly unattractive client against all the odds. How can they appear for people like that when they know they're guilty, she would ask me. And I would explain to her that it's not for the lawyer to judge his client. The lawyer's duty is fearlessly but fairly to present his client's case in the best possible light. The lawyer on the other side can be relied upon to redress the balance. In this way, both the strengths and weaknesses of the case should be exposed, and the tribunal, be it judge or jury, best placed to make the just decision. Every judge in England takes an oath. It is to do right to all manner of people after the laws and usages of this realm without fear or favour, affection or ill will. That oath is particularly important in times such as the present, when our world seems under threat, both from terrorism and now from the apparent disintegration of what had seemed to be rock-solid financial institutions. There is a tendency, at times of emergency, for the executive to think that the safety of society calls for suspension of some parts of our law. Terrorist suspects must be detained without trial in the interest of protecting society from being blown up. The ends of obtaining information necessary to combat terrorism justify questionable means. Bankers who've grown fat on bonuses without protest from any of the millions who are happy to take their share of growth and prosperity that seem designed to go on forever should be stripped of their wealth by retroactive legislation. Citizens, frightened, bewildered, and angry, may well accept the necessity for such measures. But lawyers and judges know better, or should do. We cannot hope to preserve our liberty by depriving others of it. I cannot pretend that my country has a particularly good track record. During the First World War, we passed regulations under which citizens were detained without trial, and we did the same in the Second World War. The Secretary of State was given the power to detain anyone whom he had reasonable cause to believe to be of hostile associations. The Home Secretary, Sir John Anderson, locked up a Mr. Liversidge and refused to give any reason for doing so. The courts held that he was within his rights. Only one judge stood out, Lord Atkin. In his dissent, he said, "In this country, amid the clash of arms, the laws are not silent. They may be changed, but they speak the same language in war as in peace. It has always been one of the pillars of freedom, one of the principles of liberty, for which on recent authority we are now fighting, that the judges are no respecters of persons and stand between the subject and any attempted encroachments on his liberty by the executive, alert to see that any coercive action is justified in law. In this case, I have listened to arguments which might have been addressed acceptably to the Court of King's Bench in the time of Charles I. I protest, even if I do it alone, against a strained construction of words with the effect of giving an uncontrolled power of imprisonment to the minister. It will not surprise you that this is the only judgment that is remembered today, not any of the subservient majority. After 9/11, the United Kingdom passed an act that gave the government the power to detain alien terrorist suspects without trial. They could only lawfully do this on the ground that there was a public emergency threatening the life of the nation. Lord Hoffman, one of our most brilliant judges, in a dissent worthy of Lord Atkin, disagreed with his colleagues on whether this test was satisfied. He said, "This is a nation that has been tested in adversity, which has survived physical destruction and catastrophic loss of life. I do not underestimate the ability of fanatical groups of terrorists to kill and destroy, but they do not threaten the life of the nation. Whether we would survive Hitler hung in the balance, but there is no doubt that we will survive Al-Qaeda. The real threat to the life of the nation in the sense of a people living in accordance with traditional laws and political values comes not from terrorism, but from laws such as these. That is the true measure of what terrorism may achieve. It is for Parliament to decide whether to give the terrorists such a victory." While all this was going on our side of the Atlantic, your courts were having to wrestle with the problem posed by Guantanamo. We watched with apprehension, but also with confidence, because for us, the United States has always epitomized the rule of law, and I believe that we are seeing our confidence justified. Respect for the rule of law must be the very foundation of our fight against terrorism. 2 years ago, with your Chief Justice, John Roberts, I took part in celebrations at Jamestown to mark the 400th anniversary of the arrival of 3 tiny ships from England, bearing the first European settlers who'd arrived to found the colony of Virginia. Members of my Inn of Court, the Middle Temple, had been instrumental in mounting this expedition, and quite a number thereafter left England to settle in the new colonies over here. In what we call the American Revolution and what you call the War of Independence, most of these were on your side. 5 members of my Inn were signatories to the Declaration of Independence, and no less than 7 signed the Federal Constitution. In so doing, we gave your country what we have never had, a written constitution and a Supreme Court. And 14 years later, that court was blessed with the appointment as Chief Justice of a man who's always ranked at the forefront of my list of heroes of the world. And I'm speaking, of course, of John Marshall. In the great case of Marbury and Madison, he invented judicial review. And judicial review not merely of the acts of the executive, but of the legislature, for he ruled that the Supreme Court had the power to strike down a statute as unconstitutional. It is this power that gives added meaning to your court's title of Supreme Court. It really is supreme, and its standing around the world, and especially in the United Kingdom, is second to none. When a member of your Supreme Court falls to be appointed, it is world news. My sister-in-law phoned me from France to tell me that David Souter had announced his resignation, and this week the London Times devoted a leader to discussion of his replacement. In Britain, we are about to have a new Supreme Court. I recently presided over the selection of 3 new members of that court. Their appointments have received no media coverage. This is in part because our new Supreme Court will not be supreme. Let me tell you a little about it, for it's a topic on which I find confusion, not merely abroad but in our own country. The separation of powers, which was and is a fundamental principle of your Constitution, was unknown in Britain at the time your Constitution was drafted. Those responsible for making our laws, in the form of the House of Lords, our upper house of Parliament, also performed the function of a final court of appeal. The House dealt with legislation in the afternoon. In the morning, it transacted its judicial business. It sat to hear appeals to Parliament from judges in all parts of the United Kingdom. All members of the House could vote on whether to allow an appeal or not, despite the fact that most of them had no legal qualifications or indeed any knowledge of the law at all. At the end of the 19th century, Parliament decided this was not a very good idea and delegated the hearing of appeals to a judicial committee made up of members of the House of Lords who'd been specially ennobled from the ranks of the senior judges. These were called the Law Lords, and they were and are still technically members of Parliament who could take part in the legislative business of the House. Over time, they ceased to do this, so that they simply acted, in effect, as a Supreme Court. Thus, there developed in practice separation of powers between the legislature and the judiciary. But this was not obvious to the man in the street, who had no idea who or what the Law Lords are. Today, there are 12 of us, but the average citizen has no idea what we do, and certainly not who we are. The current administration decided to change this and legislated for the creation of a Supreme Court. This is going to open for business on October the 1st in a courthouse which has been specially converted. It stands opposite the Houses of Parliament on the other side of Parliament Square. The 12 Law Lords will walk across the square and turn into justices of the Supreme Court of the United Kingdom. The difference between our Supreme Court and yours will be that ours cannot strike down legislation as being unconstitutional. This is because under our unwritten constitution, Parliament is supreme. It can pass any law it wants to, and the judges have no choice but to apply it. Well, you'll be glad to hear that's the end of the history lesson. It is customary on an occasion such as this for the Speaker to give the new graduates a piece of advice. When I was trained for the bar, we were given a golden rule of cross-examination. Never ask a witness a question unless you know the answer that he is going to give. That made it a little difficult for my opponent on one occasion when I appeared in what is called a scuttling action. My client's elderly ship had sunk in calm weather in the South China Sea, and they'd claimed against their insurers on the basis that it had suffered a fatigue crack in the shell plating. The insurers alleged that, on the contrary, my clients had sunk their ship on purpose to get the insurance monies by paying the second engineer to open the main sea suction valve. The crew of my client's ship had been rescued by a tug and taken to Hong Kong, and we'd used a private inquiry agent to take a statement of their evidence. I decided that it would be preferable to put these statements in evidence rather than call the crew to give oral evidence when they would be subjected to cross-examination. But I could only read these statements if I could prove that they had been made by the crew. Normally, this would have been admitted. But the insurers, just to be difficult, insisted that I call the inquiry agent all the way from Hong Kong to prove that he'd taken these statements. This did not take very long. You practice as a private inquiry agent in Hong Kong? Yes. Did you take these statements from the crew? Yes, I did. Are you sure that they are accurate? Yes, I am. I sat down. My opponent, David Steele, Queen's Counsel, now the Admiralty Judge, stood up to cross-examine. It was obvious he hadn't got the slightest idea what to ask. How long have you practiced as a private inquiry agent in Hong Kong? 5 years. Well, what did you do before that? I was in the Hong Kong police. Not a very good answer for him. Long silence. Well, did you go straight from the police to being an inquiry agent? No. Oh, well, what did you do in between? I was in prison. For how long? 4 years. What for? Perverting the course of justice. And so I'm not going to advise you not to ask a witness a question unless you know what answer he will give. Instead, I am going to wish all of you every success and happiness in your chosen careers.